Welcome to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And we are live on Who Wrote That Up For You. Today is Monday, October 3rd, 2022. I'm Sonia Ebron, a co-founder at Courtroom 5.
And I'm Deborah Sloan, the other co-founder at Courtroom 5.
We have a marvelous show for you today. In a few moments, we will speak with Ed Walters. Ed is the co-founder and chief executive at Fastcase, and an adjunct professor at Georgetown Law, and just one of the major thinkers in the future of law. So really excited to have a discussion with him today. But before we get there, Deborah, what is on your mind today? What is our issue of the day?
Well, it's not an issue so much as an insight. I read a study that said that in federal court, there are more pro se plaintiffs overwhelmingly than there are pro se defendants. And I've known for years that the opposite is true in state court, that there are more pro se defendants than there are pro se plaintiffs. And a lot of these pro se litigants are up against lawyers. And one thing that I noticed is that in almost every case, a lot of them are fighting for liberties or rights or civil to be treated fairly. There are lots of eviction, lots of foreclosure cases, debt collection. Almost like a poor tax. and in those courses in state court. So I'm just aware that both in state and federal, that it's always an issue of someone's rights that they're going to protect.
It is interesting. I think that there are so many more, there's just such a disparity between the state and federal cases there. I think the last statistic I read that was that 99% of cases were filed in state courts. And so, it's really interesting that most of our plaintiffs would be in federal courts, in those bankruptcies and those civil rights claims, et cetera. Very, very interesting insight, though. It's all about protecting our rights, whether you have to be a plaintiff or defendant, whether you're in state court or federal court. Yeah, it's all about maintaining our rights and privileges. Very interesting insight. Thank you for that, Deborah. Who Wrote That Up For You is sponsored by Courtroom 5. As you know, at Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. And so if you are in court without a lawyer, or if you need to sue someone and can't afford a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and hopefully we can provide some relief for you. At this time, it is my great pleasure to welcome onto our podcast Ed Walters, the co-founder and CEO of Fastcase. Thank you so much for being with us, Ed.
Hey, thanks for having me, Sonia, Deborah.
Fantastic. Ed, tell us, first of all, what is Fastcase? It seems like every time I turn around, Fastcase is there. You all are just providing a wide variety of services. Give our audience a sense of what all you all do there.
I would say we're really aligned with Courtroom 5. So the idea of Fastcase is to democratize the law, to make it work for us, to make sure more people have meaningful access to the law, and that the law just works better. And so over the last 23 years, we've taken a system that was really designed, I think, to bottleneck access to the law in two kind of duopolist providers. And Fastcase has really been trying to smash the bottlenecks to make sure that law is something more like electric power. It's available broadly, it's inexpensive, and it can empower people and providers and people who want to help, like Courtroom 5, to create all kinds of interesting applications, using the law. And so that's the kind of idea behind Fastcase, that the law can be a very empowering service that we can use to really help people at scale.
Extraordinary. And from previous conversations between us, we certainly see you all as fellow travelers on this access to justice mission. No doubt about it. I should tell our audience that we've partnered in a number of ways. And so one of the tools that you all provide is access to the nation's case law. And that's something we've wanted to provide to pro se litigants through our services. And thanks to our partnership, we are able to do that using Fastcase's data set. You all have also helped to introduce particularly small and solo firms to the opportunities we have to serve pro se litigants with legal services. And so we're very grateful for the partnership. Well, let me ask you, Fastcase has been in the market in some way for, I think, decades now, if I'm not mistaken. What did you see? Tell us a bit about the origin of Fastcase and what you saw as the opportunity, and just more about that, ability that you wanted to create to serve more people, to open up that bottleneck. How'd you get started?
Yeah, thank you, Sonia. So I grew up in a litigator's house. My dad is a small firm lawyer in Baton Rouge, Louisiana. And so I grew up really in an environment where law firms serve to help people. And I also saw that when it came time to get access to the law, my dad's firm was always disadvantaged. It was a firm that was very successful, right? But unless you were one of the biggest firms in the world, it was very hard to get access to the law. Fast forward a few years, when I had finished law school, I was working in a big firm in Washington, D.C. And even our very well-funded corporate clients had a hard time finding access to the law. One of those clients came to me one day and said, "Ed, we've got a question. The answer is going to be in case law, but it's a software question. It's too new to be in the books. You'll need to do the research online. We need an answer by tomorrow morning. Oh, and don't use the two big services that everybody uses for this." And I said, "Well, guys, that's what we're subscribed to. What's the problem?" This was a big company, let's say that, a Fortune 5 company, that their biggest legal problem that year was, what do we do with all this money, right? And I said, so it can't be a money problem, right? And they said, no, it's absolutely a money problem. We have 300 law firms who do work for us, and they all use those expensive services and then pass the costs through to us. And so we're spending tens of millions of dollars for other people's legal research. We don't pay to put the books on your shelf. We're not going to pay to put them on your computer either. Go find some other way. And I couldn't. So 1:00 in the morning, I'm punching the printer in my office suite, and my next door neighbor comes in and says, "Ed, what's wrong?" And I said, "Look, I was looking for whatever the next big alternative was, and I couldn't find one. And I don't understand it. We pay taxpayer dollars, like we the people, as you say, pay taxpayer dollars to pay judges and clerks and legislators and agency regulators to get the law right. And then we give it away to foreign-owned publishing conglomerates, to duopolists, who sell it back to us, who restrict access to it." And at the time, it was like $500 an hour, $100 a search. And I said, the software is even terrible. So I've got half a mind to go start the thing that I was looking for all day, and create some disintermediary, like some disruptor in this market. There's got to be a better way to get access to American law. And so that was the origin story of Fastcase. My co-founder, my next door neighbor at that law firm, Phil Rosenthal, and I left this very nice law firm job to go start working in my living room, trying to create the big alternative to that duopoly. And I would say, fast forward to today, in many ways, we are right on that path. Fastcase has more than 210,000 users every year, more subscribers than either of the two incumbents in the market. We work with virtually every state bar association in the country who makes access to Fastcase available to their members. And we work with very influential companies like Courtroom 5 to make sure that that law is accessible to people, to empower them to take action in their own legal matters where it's appropriate.
That's extraordinary and very kind of you. And thank you so much for that background. Deborah and I will take a break here. We'll work our challenge to the audience. I'd like to have you back for a deeper discussion, a little bit deeper dive on some of the barriers you see in the industry. We'll be back in just a moment. Extraordinary. I'm looking forward to the second part of
Yes.
the conversation.
Yeah,
That's
he's
great.
speaking our language.
Yes, he
Okay.
is. Yes, they do. Fantastic. Deborah, what is who won last week's challenge, and what do you have teed up for us today?
Last week's challenge was evidence is covered in discovery using four main instruments. What are they? They are admissions, interrogatories, production of documents, and depositions. Admissions ask an opponent to either admit or deny a statement. Interrogatories, they're basically general information and also questions, maybe some background questions. And production of documents is just how it sounds. It wants you to produce, your opponent might want you to produce a set of documents. And then deposition is a witness testimony outside of a courtroom. The winner is Shelley R. Congratulations.
Congratulations to Shelley
All
there.
right. Today's quiz. A motion is one, a request to a court for an order. Two, a document opposing a discovery request. Three, a statement made under oath by a witness. Or four, a statement outlining why evidence is admissible. If you want to participate in the quiz, send your responses to quiz@courtroom5.com.
As always, looking forward to the answers to those questions. That's fantastic. All right, let's have Ed back on and take a bit deeper dive, Ed, on some of the bottlenecks or barriers to accessing the law. What do you see as sort of stymieing access to the law right now? What's in the way?
Well, there's a lot of structural barriers. I mean, I sort of separate out access to justice and access to a lawyer and access to the law as like really separate versions of the problem. My professional job is really working on the access to the law itself, and I think one of the problems there is that courts release the law in a million different standardless ways, Word docs and PDFs, and they're all in different formats, and they all have different kinds of information. A big impediment there also is that it can't be officially cited until it's published in a book. And those books are proprietary and expensive and anachronisms. Like no one is reading those books, they're all accessing the opinions online. And so all it does is means that people who want to disrupt, like Fastcase, have to wait until the books come out and then like literally type in every page to make sure we're only getting the uncopyrighted stuff and then the specific page breaks. If courts release the law in a public domain way with media neutral citations that don't rely on books, then we could all use it officially straight from the court. Anybody could go to a court's website and download the opinion from the court and use it right away. But that's sort of access to the law. I would say, access to justice lives in a slightly different world. And a question I've been thinking about a lot recently is what would our court system look like if it were designed from the start just to help people? If courts were designed for people first, there's a law professor named Bill Henderson who has this great kind of breakdown of corporate law versus people law. And he says like the kind of legal education system is really targeted towards corporate law. And in many ways, our court system is designed for corporate law, or at least, well-represented litigants. But unfortunately, the structure of the business of law right now is all structured towards corporate law and none towards people law. And so that's one of the biggest breakdowns. Our court system is structured for represented parties in typically civil corporate matters. And even criminal law cases are really structured for criminal defendants who are represented by counsel. And just as a thought experiment, like what would it look like if courts were structured to handle the vast majority of cases, which are people law cases? And, you know, if lawyers representing corporate parties were navigating the people law designed courts instead of people trying for themselves to navigate corporate design courts. And I don't think this is malice on the part of courts. It's not like courts don't care about people. I think they care very much. But institutionally, courts aren't rewarded for designing for people. They're not rewarded for, people being able to help themselves in court. And that's not to say, again, like that all people should, but for the people who do, they shouldn't be disadvantaged. And so if you just imagine that lawyers could help corporations or lawyers could help clients navigate a system that's designed for people instead of people trying to navigate for themselves, a court system that's designed for represented parties and corporate parties, then it would be like a fundamental change in access to justice, right? And again, like I want to make sure I'm drawing this dichotomy. For some people, it's synonymous to say access to a lawyer is access to justice, right? But I think Courtroom 5 and many other wise people would say that, even having a lawyer doesn't guarantee you access to justice. And if the justice
Absolutely.
system was designed for access, then you might not need a lawyer for many matters. And I just one more thought about this. Imagine if the medical system were designed this way. If someone who gave you aspirin were, kind of subject to jail time for the illegal practice of medicine, if a chiropractor was at risk of being put in jail for helping you to align your back or something, there's lots of professions like accountants where the practice is specialized and important to get right, just like the practice of law is. But they're not regulated in the same way that law firms are. And so I would just say that if we could imagine for a minute that law isn't unique, that law has maybe the same kind of integrity as medicine or accounting or other major professional professions, then we might not regulate them much differently than we do all these other professions.
Extraordinary. You've said a lot there, and obviously we could spend a good bit of time, and I hope we will. Let me just dive under the hood on the earlier point you made. There is access to the law, and then there's access to justice, and it seems to me that in both those domains, it's the courts that ideally would act to change to provide access to in both those areas. We both know that's not going to happen in any meaningful time frame. We both know people in the courts who are doing just wonderful work, extraordinary work, trying to make those changes. But it's a heavy lift for an institution like that. And obviously, that provides the opportunity for a Fastcase, for a Courtroom 5, for many of the other software and data tools to make money, to be here, right? And what do you see though as the opportunity for the courts to make meaningful changes in the near term?
Well, I would say that inherent in your question is the idea that it's not any one party's responsibility. It's not just the courts. It's not just pro se litigants. It's not just law firms. It's not just legal tech companies. It's really all of us. We're all going to have a part to play. I would say courts have an important part to play because they're the ones who have the greatest ability to change sort of the systemic issues in access to justice. But if courts made all of those changes, there would still be important roles for law firms to play, for pro se litigants to play, for the justice sector and nonprofits to play, for legal tech companies. We're all going to have responsibilities to make the system better and more responsive for people. And so I would say that the biggest thing for courts is maybe they should spend a little bit of time working on empathy for people who are going through that process. So there's not a lot of judges or court administrators who make their way through. There's a great TV show called Undercover Boss, where like the CEO of a company takes a line job, like an entry level job in the business, to see what it's like, to understand better what people are going through, and to understand maybe the disconnect between the C-suite and the kind of newest worker on the team. It would be great if courts did like a little bit of undercover boss work, if they themselves try to navigate these justice systems without the benefit of counsel. I mean, even as lawyers, right? I think it would be very difficult to do. And so empathy might be the most important thing that courts can have in this process. I don't think it solves everything. We've all got a lot of work to do, but that would be a great start.
It's a fantastic challenge as well to the courts. One final question then. I know I've seen you talk about the importance of dockets as a key to unlocking some of this challenge, some of this accessibility to the law. First, for our audience, what is a docket? And secondly, can you expound a bit about why you think access to dockets is so important?
Yeah, sure. So if you go to a courtroom in 1980, if you go to a court clerk and you say, what's going on in this particular case, they would pull a paper file out of a drawer and they would open that file. There'd be a stack of documents. And the top document would be like a table of contents that's called a docket. And that tells you what documents have been filed in that individual case, in what order, on what date, by what party. And if you read it, it reads just like a table of contents. In the more modern times, those are online now. And so these docket sheets are really just kind of an online listing of what's been filed in a case. And then kind of a compendium to what electronic documents you can find filed in that case. Now, in the individual, it's kind of boring. It's a table of contents. But what I think is really interesting about them is every one of them is a map to a path through the justice system. And just like the early days of cartography, when you aggregate a lot of these maps, there's a ton of information in them. And what I love about this is that travel used to be a very highly specialized thing. People didn't take vacations in the Old West or, across Chinese mainlands, like, because no one knew where to go. It was dangerous. It was risky. It was expensive. Many of the same reasons people don't take trips through the justice system. And so the idea is that the more we understand those journeys in the aggregate, the less risky it becomes for people to take those trips. The more we understand about how much they'll cost or what the likelihood of winning is going to be. And so just understanding that information for cartographers radically democratized travel. And in the same way, the more that we understand these paths through the justice system, the more we have the opportunity to democratize trips through the justice system so that more people can understand what it's going to be like, and we can have better visibility into what the likely outcomes are.
That's extraordinary. I'm going to clip that quote and put it in our investor deck. That's exactly what we're working to do at Courtroom 5. I really appreciate that.
Yes, and we too. That's the docket alarm story at Fastcase. We're collecting now 700 million cases, documents, briefs, pleadings, and motions to better understand what litigation looks like for parties.
Fantastic. Extraordinary. Ed, I'm going to put your domain name up on the screen here, but where else can people find you online?
You can find me on Twitter. with stupid insights about baseball and cooking and occasionally legal services. That's at EJ Walters. Unfortunately for my Washington Nationals, you won't have very much baseball beyond the next week. But you'll still find, insights about coffee and pop culture and legal tech.
Especially about legal tech. I can't speak for the
Yes.
cooking and the baseball, but the insights on legal tech are absolutely worth the visit there. Ed, thank you so much for your partnership, for your friendship. We will have you back on again to dive into some of these issues again. There's a good reason why you're recognized as one of the best thinkers in legal tech, and we appreciate you. Thank you so
Thank you
much.
for having me.
Thank you. All right. All
My
right, that
good.
was great. I'm ready to
Extraordinary.
send a I'm ready to send a fake judge into a courtroom now, to
That
be a
would be
pro
fun.
se. I'm
Yes,
serious,
we need to set that
Wow.
up. Yeah, we need to set that up. That is extraordinary. Well, great. Thank you to Ed. Thank you to Fastcase. And that's all we have for you today. As always, we will see you again on Tuesday. Thanks, everybody, for joining in.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.